let me start by thanking warmly the organizers and the Academy for its kind invitation. And special thanks to Peter, who extended this invitation to me. So I'm very happy to be here. I was in Budapest long ago, last millennium. There was a training, so I came to Budapest to learn, to start my learning. Let's say a long decade learning of human rights. So as I said, I'm happy to be again in Budapest as part of this continuing learning process. What I'm going to talk about today is to use the figurative expression of a prominent German scholar, how the very same foxes, which are called to guard the chickens, are also called upon to keep an eye on the other foxes. This is exactly an interstate application under the European Convention on Human Rights is all about. Indeed, it is the responsibility of the 46 member states of the Council of Europe, state parties to the Convention, as the foxes called upon to keep an eye on their fellow foxes, to collectively guarantee the rights and freedoms defined in the Convention and its protocols. In essence, interstate application under the European Convention on Human Rights is an instrument, along with individual complaints, to ensure the observance of the Convention obligations of the state parties. Article 33 of the Convention reads, any high contracting party may refer to the court any alleged breach of the provisions of the Convention and the protocols thereto by another high contracting party. Please pay attention to the text. Any breach of the Convention, any breach. It could mean that, theoretically, a state party may refer to the court not only alleged violation of a human right, but also other breach, let's say a breach of any other convention provision. Let's say, for example, Article 46, under which state parties abide by to comply with the judgment to which they are party. So, can we stick to such a broad interpretation? At least the text of the Convention, the text of Article 3 says so, but I think in one case, Slovenia, Croatia, against Croatia, the court made it clearer that here any breach of the provision means genuine allegation of a violation of human rights. So it's in fact the same as an individual may complain about before the court. So far there have been over 30 interstate applications, and the latest one was lodged with the court just 5 weeks ago. Slovakia, Alena is not here. Slovakia, not Alena, of course, not our colleague. Slovakia, the government, decided to apply to the court with there is, and this is a, let's say, an interesting case, because I intended to speak about conflict-related interstate case, but this is not. So Slovakia's allegation raised to one specific individual, Slovak national, who was allegedly ill-treated at Brussels airport, and he was subjected allegedly to physical restraint by the police, by the Belgian police, during his detention in a cell at the airport. So Article 3, Article 8 are among the provisions invoked by Slovak government. So more than 30 applications, interstate applications. The first one, starting from 1956, Greece against United Kingdom. For comparison, for over 65 years, the European Court of Human Rights has dealt with over 1 million individual applications. 31 million. Most of the interstate applications have been launched in the last 2 decades. As I said, by and large, they concern armed conflicts. Almost 15% of all pending applications before the court relate to interstate conflicts. The interstate complaint mechanism before the European Court of Human Rights is considered to be the most effective among similar international complaints procedures. The rationale of this procedure is highlighted in the preamble to the Convention, which is the collective enforcement of the Convention rights. Back in 1961, when Austria brought proceedings against Italy in the context of diplomatic protection, and the case concerned 6 nationals, 6 individuals, their right to fair trial of 6 individuals who had been tried in Italy, in South Tyrol. And in that case, in reply to Italy's objections, the court said that when lodging an interstate application, the high contracting parties are not to be regarded as exercising a right of action for the purpose of enforcing their own rights, but rather as bringing before the Convention organs an alleged violation of the public order in Europe. Public order of Europe. Certainly, this statement should not be understood as implying that all interstate complaints are genuinely aimed at defending the so-called European public order. Substantially, some of them serve private state interests. One has to differentiate, for example, the case of Denmark against Turkey, 1997. The case concerned one individual, Danish national of Turkish origin, and Denmark, Norway, Sweden, and the Netherlands against Turkey, in which various violations following the coup d'etat in Turkey in 1980 were alleged, and in which no national of the applicant states had been involved. Or private cases where states pursued their private interests. One can also mention Ireland, United Kingdom, 1978. Then Slovenia against Croatia, I mentioned this case. Liechtenstein against the Czech Republic. The last one still pending. So in these cases, the private interest of states is conspicuous. And some interstate complaints, they were essentially a form of diplomatic protection. I mentioned Austria, Italy. I mentioned Denmark, Turkey. One can also mention Latvia against Denmark, which also concerned one Latvian national who had to be extradited to South Africa for abduction of the child, and then she was arrested in Denmark, and prior and pending her extradition, Latvia came to the European Court, and then there was a friendly settlement as a result, and the lady was able to come back to Latvia. So all these cases are purely a form of diplomatic protection. But what about the applications like Georgia-Russia number 2, relating 2008 war, and the applications lodged by Ukraine against Russia relating to Crimea, Eastern Ukraine, or 2022 full-scale invasion. In view of the scope and nature of the complaints raised respectively by Georgia and Ukraine, dealing with allegations of gross and large-scale violations of human rights and humanitarian law, one might argue that Georgia and Ukraine, they are not only defending their own nationals, but also the public order in Europe. The fundamental values that underpin the Convention. Yet, one fact is noteworthy, that only in the last case, Ukraine against Russia, and only one of these applications, 26 state parties to the Convention, first being the Netherlands, they have intervened as a third party in the interstate proceedings initiated by Ukraine. Apart from interstate cases, I think I have to also mention this, there are also so-called quasi-interstate cases, the object and purpose of which are very similar to those of interstate cases. Sometimes such complaints, these complaints are called as disguised interstate cases or interstate cases by proxy. For example, Luizidou against Turkey, Chiragov and others against Azerbaijan, or Sargsyan against Chiragov and others against Armenia, or Sargsyan against Azerbaijan. The principal purpose of these applications was to seek the establishment of the respondent state jurisdiction, extraterritorial jurisdiction over certain areas, and the responsibility of the states for various violations of the Convention, of which the given applications were presented simply as an illustration. In such cases, it's not surprising that the state of the applicant's nationality joined the individual complaint proceedings. Now I want to return to the strengths and weaknesses of the interstate complaint mechanism. If to compare with the International Court of Justice proceedings, the Strasbourg mechanism has a clear advantage. And if you also compare to most quasi-judicial mechanisms under the relevant international human rights treaties, where the operation of these mechanisms is dependent on the consent of states, the European Convention of Human Rights provides for compulsory jurisdiction and thus easily accessible. And this has been so from the very outset, whereas individual application procedure had been optional up to 1998. For example, when Austria brought proceedings against Italy, Italy had not yet recognized individual application mechanism. France only recognized this in 1981, and so on and so forth. Second strength, second advantage, is that interstate applications serve, they enable actio popularis action. My dear colleague Timake mentioned this as regards individual complaints, actio popularis, that are not admissible by the court. But as regards interstate cases, actio popularis is allowed. By the way, for further reading, I would be pleased to refer you to a recent brilliant publication by Timake and Isabella Rizzini, researcher from Germany, exactly about interstate complaint procedure under the European Convention of Human Rights. Certainly I benefited from your publication, Tim, while preparing this presentation. Unlike individual applications where the applicant must be a victim, in the case of interstate applications, any contracting party is entitled to bring before the court against another state party, even if the alleged human rights violations do not concern or directly injure the applicant state. So victim requirement does not apply to interstate applications. Even those seeking just satisfaction for specific individuals. But it's important for the applicant states to identify the victims in whose favor they are arguing the case and submit evidence that those persons had indeed suffered from the alleged violation. Otherwise, the court, despite having found a violation, will not subsequently award any just satisfaction. For example, Georgia Russia number 2, the Georgian government had provided a list of 1,408 alleged victims of the administrative practice of torching and looting of houses in the buffer zone. The court said that the evidence submitted by the applicant government had not permitted the court to establish that the houses allegedly torched or looted had belonged to the persons on the list or had constituted their home or dwelling within the meaning of Article 8 of the Convention. Accordingly, the court was not in a position to make an award in this respect. Third element, strength, probably can be characterized as strength, is that interstate applications, they raise wider spectrum of allegations than individual complaints. The interstate application has been a crucial means in addressing widespread systemic human rights issues and crises, including armed conflict. Of course, commentators, they do not have a unique position. One might argue that the convention mechanism is not designed to deal with such large-scale violations or armed conflicts, such crises. And this was not initially designed to be so. Another view would be about what to do with such flagrant and mass violations taking part in Europe when there is no other mechanism that could effectively deal with those allegations. So today, I think the European Court of Human Rights can be seen as the only mechanism to deal with such allegations. With all these, of course, restraints, with all limits, resource limits, and other procedural restraints, like, for example, evidence, fact-finding, and so on. I will mention this. But still, that's the fact that this is a mechanism that must address these kind of allegations. And the possibility to address administrative practices, systematic also, I can use both, violations and legislative measures is a central feature of interstate applications. Then another advantage could be, probably I think that's important to mention, but here again we need further clarification, is that unlike individual applications, interstate applications, so application by one state against another contracting party, are subject only to admissibility requirements: non-exhaustion, domestic remedies, and 4-month rule. As you know, there are several admissibility criteria, which are mainly referred to in Article 35 of the Convention. And from the text of Article 35, one can see that most of those criteria, they are related to individual complaints, but not to interstate complaints. So 2 main admissibility criteria: non-exhaustion and 4-month rule. But it doesn't mean that, of course, the court will not apply other admissibility criteria under general international law. The court has repeatedly said in several interstate cases that, for example, the court will not admit wholly unsubstantiated allegations or allegations that do not constitute genuine allegations of violations of human rights. In the case Ukraine and Netherlands against Russia, the respondent government, raised several objections, challenging that this application, especially brought by Ukraine, is abuse of right to application and is not a genuine allegation of violation of rights, by advancing several objections, saying that this was like form of political propaganda by Ukraine, or like the lawyers, these absolutely they are not substantiated, these allegations, or lawyers of the Russian government, they had been subjected to cyber attacks and so on. And the court had to deal with each and every objection, and as a result, of course, the court dismissed all these objections and found that here the court has before it genuine allegation of violation of human rights within the meaning of Article 33 of the Convention. In 2020, in the case of Slovenia-Croatia, which related to proceedings brought by a Slovenian bank, Ljubljana Bank, to collect debts owed by Croatian companies, the court held that it had no jurisdiction to take cognizance of the application. That was an interesting decision by the court. Even prior to verifying this admissibility criteria, the court, by referring to Article 32 of the Convention, which deals with the jurisdiction of the court to deal with cases before it, the court stressed that the Ljubljana Bank was not a non-governmental organization for the purposes of Article 34 of the Convention, and as such, had no standing to lodge an individual application. Accordingly, Article 33 of the Convention does not empower the court to examine an interstate application alleging a violation of the Convention right in respect of this legal entity. So, accordingly, if talking about non-exhaustion requirement, one can, I think, even without knowing well the case law, you might easily come to conclusion that if we are talking about one specific case, one specific individual, like, let's say, Denmark, Turkey, or Slovakia, Belgium, Latvia, Denmark, and so on, here, of course, this is the state's duty, the applicant state duty, to have exhausted domestic remedies before lodging an application. So the individual concerned must have exhausted domestic remedies. But if the applicant government alleges and provides prima facie evidence that this is not an isolated violation, but so-called administrative practice, then there is no need to exhaust domestic remedies. Because by definition, if you have systematic violations and also official tolerance by the state authorities, that means there is no effective remedy. How can you talk about an effective remedy if you have such scale of violations and impunity, lack of reaction, effective reaction by the respondent government? So the notion admitted practice is something that's used by applicant governments, especially when alleging large-scale violations, in order to escape this requirement, non-exhaustion. What's administrative practice? I'm sure that you know, but let me just repeat. As I said here, administrative practice is a concept developed in the court's case law, has two elements: repetition of acts and official tolerance. Repetition of acts, the court describes, is accumulation of identical or analogous breaches which are sufficiently numerous and interconnected not to amount to merely isolated incidents or exceptions, but to pattern or system, while official tolerance means that illegal acts are tolerated, in that the superiors of those immediately responsible, though cognizant of such acts, take no action to punish them or to prevent their repetition, and that a higher authority, in fact of numerous allegations, manifests indifference by refusing any adequate investigation of their truth or falsity, or that in judicial proceedings, a fair hearing of such complaints is denied. At the admissibility stage, as I said, the required threshold to demonstrate that there is administrative practice is prima facie evidence, which must be more than mere allegation, certainly. If some of you are interested in more details, especially interpretation of what repetition of acts means, and namely, even more specifically, numerous violations, I would ask those to look into the case Ukraine and Netherlands against Ukraine against Russia concerning Crimea, merits, not admissibility stage, but merits, where the court interpreted the notion repetition of acts, and specifically what means numerous violations as regards alleged violations of alleged enforced disappearances of activists, Ukrainian activists, and persons of Crimean nationality, ethnic origin in the Crimea. Interestingly, the second Greece and United Kingdom case, where Greece complained about the ill treatment of 49 individuals. Some of the individuals in that case, they have failed to exhaust domestic remedies. At that time, of course, the convention bodies, the commission had not yet developed exceptions to the rule of exhaustion of domestic remedies. And therefore, that part of the complaint was found to be inadmissible. Today, it wouldn't have been possible. Today, in my view, the case would be an example of administrative practice, 49 individuals, and thus the requirement to exhaust domestic remedies would have been dispensed with. Now, weaknesses, challenges, limitations of interstate applications. They are more than strengths, unfortunately. Probably to start with, one could probably start, of course, I mean, there's no, let's say, strict logical consistency, but one could argue and advance, probably, I think, the most visible and conspicuous weakness is execution of interstate judgments. Execution. The court, of course, has also problems with execution, implementation of individual judgments, but all the more so this relates to interstate judgments, specifically those judgments that relate to armed conflicts. And you may easily guess what's the main reason behind this. Of course, political considerations and sensitive issues for the states involved, specifically for the responding government in that case, not to implement those judgments. And here, unfortunately, we as the court have very little to say about any real success story. And plus, compensations awarded in these cases are very high. And by and large, the same difficulties apply in the so-called quasi-interstate cases brought by individuals in the context of armed conflict. The first time, let's take, probably, of course, execution of judgments, as you know very well, is not only awarding and paying just satisfaction. This is only one element of complying with the judgment. Also, individual and general measures must be taken by the respondent government to comply with the judgment. Otherwise, the Committee of Ministers will continue dealing with the case in the context of supervision over execution of judgments. But talking about awarding just satisfaction, the first case was Cyprus against Turkey. As you may well remember, in that case, 90 million euros. This amount was awarded by the court, and this case remains unexecuted. Georgia, Russia, number one. The court also awarded monetary compensation, 10 million. There was also joint concurring opinion. My dear colleague, Lado Chanturia, and your obedient servant was we were one of that minority which submitted joint concurring opinion to that just satisfaction judgment. But no money has been given by Russia up to now. There were some developments until 2020, end of 2021, because to establish mechanism, and Russia appeared to get involved in this process, to pay this 10 million, and then through this Committee of Ministers mechanism, and then to be distributed by the Georgian government to injured individuals. But then, of course, after February 24, I think no need to talk about what happened with these developments. And then Georgia, Russia, number two, in April 2023, the court awarded about 130 million euros, having previously found various violations committed under the Russia jurisdiction. And I leave to you the answer to the question whether this compensation will ever be paid by Russia. And I must add that compensations awarded by the court, they failed to implement full reparations in the context of armed conflict. Even, I think, that's also the reason is clear. Of course, it is not the court's task. If you, for example, to look at the two quasi-state interstate cases, one is, I already mentioned, Chiragov and Dades against Armenia and Sargsyan against Azerbaijan. In those cases, the court awarded minimum amount of money, 5,000 euros each applicant, 5,000. Can we say that this is really just satisfaction vis-à-vis the violations claimed? Article 8, and specifically Article 1, Protocol 1, demolition of property and applicants not being able to peacefully enjoy their possessions. As I said, monetary compensation is not the only form of responsibility of states under the Convention. To duly execute a judgment, the respondent states must take appropriate individual and general measures. In this regard, it's not clear what kind of general measures must be taken by the respondent state in an interstate case in order to prevent, specifically relating to armed conflicts, in order to prevent similar violations in the future. That said, probably I have to mention for this some, let's say, good examples, good practices. Indeed, interstate applications yielded results before a formal decision by the Convention organs was taken. of course, even if not in all cases. For example, 5 notorious interrogation techniques, I'm sure you're all aware of these 5 interrogation techniques that had been applied by UK authorities, and the court found them to be inhuman and degrading treatment, so violation of Article 3. They were no longer applied in the context, already in the context of proceedings, Ireland against United Kingdom. Certain types of punishment, including what the Greek government complained of as whipping, as well as capital punishment, were no longer used in Cyprus upon the initiation of the proceedings in Greece against United Kingdom. So back in 1950s. Another challenge, major challenge and weakness is that interstate cases, especially those dealing with armed conflicts, require the court to examine and assess enormous amount of evidence concerning a significant number of victims. And the court has to establish facts that are highly contested by the parties. This task is time and certainly resource consuming. For example, Ukraine, Netherlands, Russia, the court noted that the factual disputes in the case were extensive. Over 1,000 different pieces of evidence had been produced, over 1,000 pieces of evidence, and many thousands of pages of supporting documentation had been submitted. So you may imagine how much time that the court need, the registry, and especially the rapporteurs, judge rapporteur dealing directly with those cases, they need in order to effectively examine those allegations, those cases. Here, as you may know, the court's approach is free assessment of evidence, including the probative value of the evidence presented. What if the respondent government fails to cooperate? Today, answer this question is clear, but it was not like this some time ago. In 1976, the former Commission, European Commission on Human Rights, faced a situation in which Turkey refused to participate in the proceedings initiated by Cyprus. In its report, the Commission refrained from drawing any conclusions from the fact that the respondent government failed to make any statements or to propose counter-evidence on the applicant government's allegation. That was in 1976. Almost 40 years later, in the Georgia-Russia No. 1 judgment, July 2014, the court stated, a failure of the government's part to submit such information, which is in their hands, without a satisfactory explanation, may not only give rise to the drawing of inferences as to the well-foundedness of the applicant's allegations, but may also reflect negatively on the level of compliance by a respondent state with its obligations under Article 38 of the Convention. Here, in that case, the court referred to the persistent refusal of the Russian government to provide copies of 2 circulars relating to the mass expulsion of Georgian nationals from Russia. These were documents which the court considered to be essential in establishing the facts. But Russia argued that they were classified as state secrets, and therefore disclosure was forbidden under Russian law. Noting that there was no specific explanation for the claim to secrecy, the court reminded the Russian government that they could not rely on the domestic law to justify a refusal to comply with the court's request for the production of evidence. In the operative part of that judgment, the court found a violation of Article 38 and put this violation, Article 38, at the top of the operative part of the judgment. So even before the substantive violations found. I also should mention Rule 44C of the Rules of Court, specifically on this matter, where a party fails to adduce evidence or provide information requested by the court, or request by the court, of its own motion, or otherwise fails to participate effectively in the proceedings, the court may draw such inferences as it deems appropriate. Failure or refusal by a respondent contracting party to participate effectively in the proceedings shall not in itself be reason for the chamber to discontinue the examination of the application. Another problem is that interstate cases last for years. So do sometimes individual applications. Some time ago, but of course, unfortunately it's rare, we examined one case against Serbia, which was lodged back 2003, 22 years. But as I said, it's rare as regards individual complaints, but interstate cases, they really last long. And the time needed to adjudicate on interstate cases has continued to increase over the years. The admissibility of the interstate cases lodged in 1950s, 1960s, and 70s was dealt with in a matter of a few months. But of course, it was clear that the court or the convention organs didn't have a backlog like these days. Now we have over 70,000 pending cases, or less. About 70,000, yeah? A bit less here now. 6 something, thanks to the fact that we have dealt with a lot of Russian cases. The number of which some years ago was about 18,000. So the first 2 cases brought by Cyprus against Turkey, lodged in 1974 and 75, were adjudicated on the merits by the then European Commission, July 76. Cyprus with Turkey, admissibility decision, then as regard complaints 90s and 2000. 19 months. Georgia, Russia, number 1, lodged in 2007. 2 years and 3 months, admissibility decision. Ukraine, Russia, concerning Crimea, lodged in 2014, 6 years. As regards the merits, Georgia, Russia, number 1, 7 years. Just satisfaction judgment required another 5 years. The just satisfaction judgment on Cyprus against Turkey was delivered in 2014, which means that 20 years had elapsed since the case was first introduced in 1994. Judgment in Georgia, Russia, number 2, concerning events War 2004, was delivered in 2021. And just satisfaction, as I said, in 2023. And let me repeat, dealt with the situation which happened back August 2008. 3 minutes we have, and I have still a lot of elements to mention. Probably I will just mention. I will start from the last point, and then I'll stop where, of course, that I have to, because just to say that another important issue is interim measures in the context of interstate proceedings, but certainly 2 minutes are not sufficient for that, or 3 minutes. And then another problem is overlapping between interstate complaints and related individual complaints. So if you have one interstate case, let's say Ukraine against Russia, and then you have thousands individual applications with similar subject matter, individual applications have to wait for years. And as I mentioned already, that lasts for years, and therefore those applications, unfortunately, have to wait until we produce final judgment. And we establish specifically the most thorny issues like state jurisdiction. But of course, it doesn't mean that all these related individual applications, they are piled up and covered with dust in the lawyer's drawers. Those which are manifestly inadmissible, manifestly founded, they are dealt with. Like, for example, there was a case, Lisnia and others against Russia and Ukraine, and since the applicants, they were not able to produce evidence concerning belonging the property to them, the court found them manifestly founded. One issue is, I think, is a sensitive one, is the role of national judges. So I put aside the issue of interim measures, but therefore now I'm dealing with the last point. The role of national judges in interstate cases. There are pending cases against Armenia, Azerbaijan, Azerbaijan, Armenia, 2 applications, Armenia against Azerbaijan, 4 applications. Mykola Grantovsky, my dear colleague, has been a national judge and is still, he will be involved. I don't know, Tim, probably you will not manage, we don't know, but Ireland has recently lodged the application, another application against the United Kingdom concerning this Troubles Act, Northern Ireland Troubles Act, and so that means we will have Irish judge and British judge. Lado Chanturia has been involved, and of course now Saadet Yüksel, we will have a case. We have a case, still pending case, Armenia against Turkey, probably against Turkey, because at that time still Turkey. This is the official title of the case. So I'm going to finish. Here, of course, the role of national judge is very sensitive. Case United Kingdom, Ireland and United Kingdom, 78, 5 techniques. Whether the Commission, by the way, had characterized these 5 methods of interrogation as torture. No comment on my side, as torture. And later the case was referred to the court, and the court, with a tiny majority, the court said no torture. Inhuman and degrading treatment. Okay? National judge, British national judge, Sir Fitzmaurice, prominent lawyer, he submitted a dissenting opinion, and the key point was that here these methods even do not exceed the threshold, minimum level of severity under Article 3. Whereas Irish judge was arguing that no, that was torture. So you see the position of national judge in those cases. And then Georgia, Russia, not you, Lado, but Nona in Georgia, Russia, saying that, talking about discrimination, admitting the practices, mass expulsion of Georgian nationals from Russia, and Russian judge Dedov blaming the court in taking up unsubstantiated and unreliable facts and so on, so denying completely the facts. And there was a suggestion not to designate the sitting judges as national judges in those cases, but rather to appoint ad hoc judges. Ad hoc judges from the list submitted by the government. Whether it's a solution or not, but I think there is some rationale behind. Not to put a sitting judge in a such delicate and sensitive position, but to have rather ad hoc judge, because sitting judge continues to dealing with such cases, and therefore I think, in a way, I brought up this issue just to say that this is also one of the challenges inherent in interstate cases. Sorry for that, I have exceeded my time, so thank you for your attention. I am ready to questions.